You can see my email, my phone number. This presentation will be recorded for you to know. And also, well, it will be available for people who can't attend today live. I'm calling from unceded territory of Mi'kmaq, Woloski, Passamaquoddy territory. This is a webinar English only. We're having a French with the same subject, exactly the same, only in French, in March 15. I have to say that there is after the presentation there is a moment for questions. I'm a lawyer, and because confidentiality, I can't answer particular question for a particular case. So general questions are welcome. I'm gonna try to answer the best of my abilities, but unfortunately, I can't answer a question for a particular case. So you can ask in a general question, and also you can also write me an email, for example, if there is something you would like to follow up. I'm the Tenants Advocate. Part of my role, is one of these, the education part of my role. That is the series of webinars we are hosting as the coalition, but also I have the possibility to guide tenants in their particular issues when they contact me with questions about how to navigate the system. So the next webinar, so as I said, it will be in French, the same subject. You can follow by Facebook. We have the Coalition for Tenants Rights have a Facebook page, have Instagram. You can sign up also at the coalition webpage. You can sign up to receive the emails, so to be updated and all the webinars and any other information at the coalition we could share. So I think that is for housekeeping. If maybe during the presentation you have a question that come up and you can't wait, please feel free to write the question on the chat. I have friends helping me with the questions, and I'm gonna be able to answer at the end of the webinar. So we'll start. Let's talk about legislation. So in December, we had a change in the Residential Tenancy Act. And that is, I thought that we will start with that because that having a lot of the news, sometimes people are not clear about what were the changes. And it's particularly about rent increase, which is something really, really a subject that's pressuring us, and people want to understand better. And landlords, unfortunately, seems they don't want to understand sometimes. So it's important that our tenants understand what is happening here. And that is the idea for today. Oops. So what were the legislation changes in the Tenancy Act? So in general, we had 3. Now the Tribunal for residential tenancies can review all rent increases. So before it was only for long-term tenancies. Now it's any rent, any tenancies, long-term, short-term, any. If there is a rent increase, you can ask the tribunal to review this rent increase. We are going to talk further, of course, later, because it has some points to make that. So the notice period for a rent increase, in general, it's 6 months. The website of the government say, because before it was 3 months, it was less time. So the website of the government say that it was to give more time to adapt. We at the coalition, we think that is just to delay the situation for people. We know, and we have been seeing how 6 months, when even the rent increase is reviewed and granted, 6 months is not enough with the market how we have right now. But that's the excuse of the government to say, oh, we changed it and we were doing things good. We don't think it was a big change, and it's not really helping tenants. But here we are, and we are talking about the legislation and what changes. So now, so the tenants have 30 days to apply. Before it was 15 days, now it's 30 days. Be aware that it's 30 days in a row. So counting Sundays and Saturdays and holidays. So you receive the notice for increase, and you have 30 days to apply to the tribunal for the review. We're going to talk later how you can apply and what you can do. So let's go about that. So review all increases by the tribunal. So as I said before, it was only for long-term tenancies. Now it's for any tenants. It can be when a tenancy runs from year to year, month to month, or week to week. The notice of increase is a document separate document from in any other notice or receipt. For example, if they are doing a termination of contract, as an option, because that is how they rephrase, it has to, the notice of increase has to be a document separate. It could be the option for the tenants. Oh, if you don't agree with the rent increase, you can leave. But it has to be, the notice of increase has to be a separate document, not with the payment, not a separate letter. So the notice of increase runs for a fixed term. So that is important. So what we were saying is year to year, month to month is 6 month notice. Fixed term is what is not false year to year, month to month, week per week. So if it's a fixed term, what is not false in this condition, year to year, month to month, so it's a next 3 month notice. But if your contract is undefined, for example, it's not fixed, so you have 6 month notice. The notice of increase have to have, so it's a letter that have to have the name of the tenant. If there is a contract where there are 2 tenants, for example, a couple, and the both of them are in the lease, so it's the name of the tenant, so it will be the 2 names. For example, the address of the rental unit, the amount of the increased rent, the date when the increase is taken to effect, and it has to be normally 6 months. The date and signed, dated and signed by the landlord or agent. So when it's a company, and it's a company who owns the building, so it will be the agent for that company, dated and signed. And why dated and signed? Because as you remember, I said it's 6 months. So it's important to know when that notice of increase was made, was dated, to count the 6 months and to count the 30 days for the application. So when they cannot increase rent, landlords cannot increase rent when is the first consecutive 12 months period of a tenancy agreement. When it's more than once in any other 12-month period of a tenancy agreement. So they cannot increase rent more than 12 months. So there is a deadline, there is a time, and it's important to know this. How to make the complaint? So the application has to be written to the residential tenancy officer, so the tribunal, within the 30 days after the receipt of the notice. So I will suggest if you receive a notice and there is this dated differently than the date of receipt, you made a person to sign the date when you received the notice, to be sure you have the 30 days for the application. I'm being sneaky, but sometimes people are sneaky, so I made my duty to tell you, well, it's better, maybe the date is different, so it's 30 days after the receipt of the notice. include a copy of the written notice of rent increase received from the landlord. So you include that copy, and it's better a copy. It's better that you keep in your records what is happening. You don't give the original. They are asking for a copy. You give a copy. The application can be online. So there can be at the website. There is you can type, if you have access to a computer, you can type renting in New Brunswick. The residential tribunal, they change it. They make it more friendly, more user-friendly, and you go online. But what you have been seeing at the coalition, many people don't have access to computers or have difficulties accessing to a computer, or even by phone is difficult, sometimes from particularly elder and seniors. They have landlines, so you can complete the forms and send it printed, or by fax, or by mail, or bring it to Service New Brunswick Center. So I encourage to, so at that moment, and it has to be with the form. So I remember at the moment we were at the coalition, we were helping some tenants who were elders, and if you have difficulties to print, to go, to move, to serve in New Brunswick, to do all these things, well, part of my role will be advocate, and I invite you to write to me or call and leave it a message. Sometimes I can't answer because I'm another call, so leave it a message with your phone number, and I call, maybe helping you to get the form. They are strict by law; it have to be written. However, the tribunal, with some cases, particular cases, has been flexible about that, which is fair. Also, how difficult it is, complain. Well, what is review? So I do the application, and what happens? What is review? So the first thing is the form of the notice comply the law. So remember the requirements for the notice. So they're going to see, and we have been saying, okay, mostly at the beginning, but maybe it's happening that still landlords don't recognize that they have to give 6 months notice. So if they don't give the 6-month notice, it's a notice that doesn't comply with the law. So it will be reviewed, and it will be an invalid notice. Or don't have all the requirement, the name, and all the name of the tenants. If the landlord is increasing the rent for each comparable unit in the same building by the same percentage. So it has to be in a building, is the same percentage for each comparable unit. So they have to see that. And if the increased rent or the screen rent is reasonable in relation to that charges for comparable units in the same geographical area. The coalition, we think, is too general, and we have been seeing, and we don't agree because I don't think it's reasonable. Also to compare it with the prices of the rent that people are renting at the moment. It will be fair, or the only solution, it will be rent control, but we don't have it in New Brunswick, isn't it? So we are trying to navigate this thing. So it could be, and I'm encouraging you, if you are applying for a rent increase, to propose, to do your research if you can, and to propose what is a rent reasonable. So, and if you have approved, for example, the area, the neighbor who has a comparable unit, and they are not paying that, so I think, and that is how it's working at this moment. More evidence you have, more leverage you have. So you can show the tribunal why you think. I understand this is not easy for many people, but if you have the possibility to do that, do it, please. And and show the tribunal. Don't wait until the tribunal, they judge by themselves. It's better if you also show your evidence. You are proactive and you show the evidence that rent increase is unfair, is not reasonable in relation with the comparable geographical area. And if you do that, please reach out to me. I'm really interested about the creativity of tenants and how we are facing this. So you can see there I put some slides my contact information. Please reach out to me. I'm really happy to help, and also I don't know all the tricks and all the situations, so I will be happy to know creative ways to overcome the situation. So in these changes, it was a transitional provision. So these changes respecting the time for the notice are valid for tenancy agreements made before December 17. So that is important to know, because that doesn't mean that. So normally when there is a change of the law, people, the act of the law starts applying for the new things. This was a transitional provision, so that means that any contract before any tenancy agreement, it's have to comply. If there is a rent increase at the time, so the time 6 months, the rent increase, the landlord has to respect the 6 months notice, even if the contract was made way before December 17, 2021. So I want to point it out about the protection against retaliatory rent increase or termination of the contract. Many people are afraid to do a complaint because that is another situation we at the coalition we pointed out many times. The act don't recognize the imbalance of power between tenants and landlords. It's an imbalance of power, and that is clear. Unfortunately, the act, the law, the tribunal, how it's made, the tribunal is made as a mediator, and it's like everyone is happy and everyone respects each other. We know that is not true. And unfortunately, the act is not seeing the unequal relationship between landlords and tenants. So it's normal, I understand many people are afraid to do a complaint because they are afraid, oh, I'm gonna be seen in the street. But while there is a protection against that, there can't be rent increase or termination of the contract. So if you do any complaint, for example, a complaint to the Human Rights Commission, if you think you are discriminated where you live because, for example, you have a disability, and because your disability, you think this the landlord is proposing you terminate the contract because, or something like that, I suggest and I encourage to do a complaint to the Human Rights Commission. The Act of Human Rights, the Human Rights Act in New Brunswick don't have the possibility to stop while investigation. So, but it's a complaint still, and it will be a protection against a retaliatory rent increase or termination of the contract. Another complaint is also a complaint to the Residential Tenancy Tribunal. Many people are afraid to complain to the tribunal, for example, and we're going to talk in a webinar later about the obligations of landlords, when the landlords have the obligation to keep clean, to keep it livable, because unfortunately I have been listening and accompanying people who are in really, really bad situations, and the landlord, and after asking the landlord about fixing the problems of the premises of the apartment, is not happening. So, and the solution, okay, if you don't like it, I terminate your contract. So I suggest and I encourage to complain to the tribunal before. So if you complain to the tribunal before, it will be a protection against the termination of the contract. Well, so it's really important that if there is discrimination, if there is complaint, if there is a situation where a child or a senior is involved, I also suggest that any complaint to the tribunal involve the child advocate and the senior's advocate. They have a scope to advocate. They are the government. I'm not the government. I'm hired by the Coalition of Tenant Rights, which is a collective of activists. I'm not the government, but the child advocate and seniors advocate, they're part of the state. They are not the government, but they are part of the state, and they have a scope to help when a child of a senior, so anyone after 65, is in a difficult situation in general. So that is why I'm really, really encouraged in other situations. It has been helping when, for example, seniors are in difficulties to file a complaint because all the difficulties, or a person or a child, for example, to have a little more time to do things. So involve them is their job, and they can help you in your situation, and to talk to the tribunal. So also, this office have a scope for people with disabilities, even if they are not children or not seniors. There is one little condition there. The person with disability have to be on social development programs. But for example, if there is a family with difficulties, and there is a child in the family, there is a senior in the family, and there is a person with a disability, so reach all of them. And also this complaint, they will help, and it will be a protection again, because we're talking about against retaliatory rent and increase or termination of the contract. So that is what I prepared, but I'm sure, and I think I have some questions, so I'm happy to talk about it. Okay.
There's a question, Jael, about what is the process to complain? What is the protection, sorry, once you complain against retaliation?
Oh, sorry. The protection, it will be for a year. It will be for a year, so the person can't have a rent increase or a termination of the contract for a year. But it's important, it's really important. And when you want to complain about the retaliation, that okay, you complain it about something to the tribunal or to the Human Rights Commission or you involve the child advocate or the senior advocate in your situation and with the landlord, and after you have a termination of the contract, and I recognize it can be tricky, but that is how it works. You have to demonstrate. So you have to demonstrate that this termination of the contract of the rent increase, it's as a result of your complaint. So I encourage really to exchange emails with your landlord, text messages. So keep track of your relationship with your landlord, and mostly if you know it's trouble coming. But also, yeah, because I recognize, and it is difficult for people, and also there is a if later maybe you have a successful case at the Human Rights Commission, for example, that will take time, but can happen. For compensation, it's important to keep it received, for example, and how much you spend in all this nightmare you had to leave because of the landlord, for example. So keep it track to show and demonstrate that this termination of the contract or rent increase is a retaliation.
There's another question that says how much rent increase is allowed, essentially. By how much can the landlord increase my rent?
Unfortunately, in New Brunswick, you don't have rent control, even if the minister says so. But we don't have it. There is not an amount fixed. That doesn't exist. There is not a percentage that doesn't exist. It's not in the law. The only thing is, as I said, is the percentage is the percentage if the same geographical area, and that is why at this moment I'm encouraging people to show that, because if the tribunal is seeing that as the offers to rent is different, and we know how the market works because we are suffering it, and if they are offering their offers for rent really high, so it's better to show that that geographical area is not normal to have this amount, to pay this amount, and that will be the only thing, yeah, people can do. But unfortunately, there is not rent control in Brunswick.
Thank you, Jael. There's another question about ending the lease agreement. Can the landlord end my lease agreement for any reason?
Can, but have to. I'm going to do a webinar in particular about that, but I can answer. I can answer a part of this before the contract ends. So they have to tell you that it's not going to continue. For example, it's a year to year before the year ends. I think it's 3 months, but I have to be sure about that. But it will be. Unfortunately, the protection is in New Brunswick. There is no security tenure here, so yeah, it could be. If there are some conditions, of course. If the landlord just say, okay, you have to go tomorrow, yeah, you complain to the tribunal. You complain because that is not how it works. Still, there are regulations. There are also steps for eviction. I'm going to talk. There is a webinar in particular about notice to vacate and evictions, because it's difficult in New Brunswick to find rules, but there are some still.
There's a question. Can you clarify again to whom should people complain and under what circumstance? The tribunal, the Human Rights Commission, or both?
Well, for the review of the rent increase is the tribunal, 30 days. In 30 days after the receipt of the notice. So that is why I remind, it's important to note the date when you received the notice, particularly if it's different than the letter, that the date that they say the letter. So that is the tribunal, and it has to be the tribunal. I also encourage to join to that if there is discrimination involved, and you feel there is discrimination because race, discrimination because age, discrimination because gender, involve the Human Rights Commission too. But for the rent increase, it's just it's a tribunal. But involving more, you can. It's better, I think. And if there is a child involved, involve the child advocate. If you are a senior, involve the senior advocate to help you to navigate and to advocate for you. That is their job.
Thank you, Jael. There's a question here. Are there any legislative changes regarding eviction notices or protection against evictions? And what kind of changes would you like to see in the Act?
Oh, no, unfortunately, the protections here in Brunswick are really, really minimal. The first change I would like to see in the act is a rent control, really. Rent control, security of tenure, and in general, but really important to have a human rights framework where it's recognized the vulnerability of tenants and the unequal relationship between tenants and landlords. So the decision and the tribunal is not necessarily neutral, but considering the vulnerability of the tenants in general, because the relationship by fact is unequal.
Thanks, Jael. There's a question. Are there any exceptions to the 30-day rule? Can a complaint still be considered I'm assuming this is in relation to asking for a rent review. Can it still be considered if it is past 30 days?
Unfortunately, there is not an exception in the law. If maybe, I will say there is an obstacle for that person, disability, for example, or something that impedes to that person, to that tenant to do in the 30 days. It has to be, but that the law itself, and it will be a big battle, and it will be really, really difficult, and probably lost. But 30 days is a hard deadline, unfortunately, for that application. And it has to be written, and that is why we are criticizing too. It's making it difficult, even if the government say that, oh, we are more flexible now and we are helping tenants. It's not true. It's not true. It's still difficult. It's still making it a difficult thing for tenants to fight a rate increase.
Those are all the questions we have so far, Jael. Just a note for everybody, if you have any questions, please send them via chat. We're not doing oral questions on this webinar, so if you can please send your questions by chat to the NBCTR questions account. Please do so now. There's a question that's come in, Jael, asking about the tribunal. The question is the tribunal truly neutral?
By law, it's made it neutral. It's what can I say? What I can say is it shouldn't be neutral. It should be helping the vulnerable, and it should recognize the inequality in the relationship. So it's and that is a thing. We are going to have a webinar also about explaining what is the tribunal, but I can't say at this moment that the tribunal is not itself a tribunal. It just have the name. But the tribunal don't have the structure. Even in French, it's called a mediator, so a mediator. So they are like, don't know what it's called, because in English it's an agent, an officer, and in French it's a mediator. So they see the act made themselves a mediator as someone who intervene, and that is causing also, and when I'm going to take advantage to say that too, when an officer of the tribunal reaches out to you with a proposition, it's a proposition. So please ask, this is part of the mediation part, because many people and some people have been accepting, thinking that was the decision. And it has been clear that it was a decision, that was a proposition, and now we have been seeing in the news, maybe some of you have been following, that leads to a really bad situation for many people, thinking that they accepted something and the tribunal say, oh, but they accepted, we were in a mediator, and yeah, I accepted because I thought that was the decision. So yeah, so if it's neutral, well, it's made to be neutral, but it shouldn't be.
Thank you, Jael. There's a question, how much notice does a landlord have to give tenants for a rent increase or an eviction notice if they are long-term tenants and not on the lease anymore?
Okay, that is interesting. So the person is no long-term, but is not in the lease anymore. So it is a contract by fact. That I understand. So because and who is living there now? So how it works is 6 months still, because that's the idea of the change. Anyone who have a rent increase have a 6-month notice, unless it's fixed term. And how the question is describing is not fixed term, so it's 6 months.
And the eviction notice, the question is also asking about eviction notices.
Well, the eviction notice, because yeah, that is how it works. So if they say, okay, we are giving you, and I have to be inspired the letter. Be careful with that. We are giving a rent increase of 6 months with before 6 months. In 6 months, we are increasing your rent, and if you don't like it, here is your termination notice to vacate. So you leave. So you choose between accepting the rent increase or vacate. So now you have 30 days to contest that rent increase, or either you are accepting or vacate if you don't contest the rent increase. I don't know if that was clear. I hope so.
Thank you, Jael. There's a follow-up question on that particular question. And the question is, can the landlord force you to sign a new lease? Can you say no?
You can say no. Always. A contract by definition is a free agreement. And be careful with that, because if forcing someone, and I know the people who are living in the situation like that, is not necessarily physical force, but there are, and that can lead to discrimination and to harassment. So harassment is a result of the discrimination. So if someone feel forced to sign a lease agreement like that, I will suggest ask to intervene the Human Rights Commission, if there is already a contract and so that is, if there is no contract, for example, and there is a situation of discrimination, for example, someone who has children can't wanted an apartment, everything was good until this person until the landlord found that there was children involved, and said, oh no, sorry, we are not renting to with families with children. So that is discrimination, and that could go to the Human Rights Commission. But if there is already a tenancy contract and the landlord wants to change and is forcing with harassment, sexual harassment, unfortunately I haven't seen that. Sexual harassment, taking advantage of vulnerabilities for seniors, or forcing, or like you have to leave unless you sign this. That is that, and there are children involved. So you do too. You complain to the tribunal and you involve either the child advocate, either the seniors advocate, and the Human Rights Commission. So you reach all, but you do the tribunal too if there is already a contract.
There's just a clarification on that question. Can you actually stay in the place if you refuse to sign the lease agreement?
Well, if there is a lease agreement already, I I think you stay with the lease agreement that exists already.
Thank you, Jael. There's one more question, so I'm just finding my way in the chat here. What kind of results do people get from their complaints to the tribunal? So, for example, if you complain against a rent increase, will the rent increase just be reduced, or will it be completely eliminated? And what happens after that? What happens? What kind of results do people get if you complain to the Human Rights Commission?
Yeah. Well, if the rent increase don't comply, it will be eliminated, and that is why it's painful, because there is no rent control. There is not, so the landlord will try another rent increase, maybe, yeah, fixing the problem that they failed before, and that is happening. For example, a rent increase that was unvalidated because didn't respect the 6 months. After the landlords did another one complying the 6 months notice. Well, it was unvalidated because it didn't respect the percentage. So they are going to do respecting the percentage. So that is the result. If it could be. About the Human Rights Commission, unfortunately, it's a long process. You could ask being anonymous, but I think it will be important to involve other people like the advocate, because what they have been seeing is people ask to be anonymous and they are not, and they say, "Oh no, we can't. We have to reach in other cases too, cases of labor and employment too." So the last time I talked to them, they said, "Oh yeah, people can ask to be anonymous," but in reality, I don't know what is happening. Because yeah, just today I received that I was encouraging someone for employment. It was another case, but yeah, she got that answer yet. So it's not ideal, and it's not what we would like to. But it can be useful. It can be useful to show and to gather evidence, because the problem, what I see here, is also because the tribunal is neutral. So they are asking for evidence too, and it has to be, and not anyone is have this facility to show evidence and to show, or maybe people don't know. People just apply and think they are gonna be judged fair, and landlords show their evidence, and the tribunal have only the evidence from the landlord, so they make the decision based on the evidence, because the tenants didn't show evidence. I know it's a high bar, but it's how it works.
Thank you, Jael. Those are all of the questions so far. We don't have any other questions waiting in the queue.
Well,
just waiting for a few more. Let's just give it another 10 seconds just in case.
Yeah, I am seeing someone sent me a question here. I think you can see, because I don't know.
Feel free to answer any question you see in your.
I'm going to read it out loud. So, whatsoever considered to remove the 2 exception for some government subsidized housing and also for cooperative housing. This kind of member of co-ops has very little protection. Well, I agree, John. No, that haven't been considered. Many of the situations, something really basic like having a human rights framework in the Residential Tenancy Act wasn't considered. Yeah, we think, or I personally think, this change of legislation was a waste of money and time, because it didn't address the real struggles that tenants are having in the province.
There's another question that came through, Jael. What do I do if the landlord does not maintain the building to adequate standards if they do not clean it properly, and like the hallways and the carpets that are common areas?
Well, the tribunal suggests to try to settle with the landlord. So I suggest you send an email, because you have to have evidence and you take pictures. And I guess when a person is complaining about that, it's because they already tried to reach the landlord and ask it and nobody answered it. And also there are emergency situations. You can't wait until really things, for example, when there are children, are there mice and rats, you can't wait until the landlord, maybe they think, oh, it could be. No, you have to act. So send an email or a text message, something that you have proof that you told the landlord. And if the landlord in an emergency situation don't answer right away, reach the tribunal and show the tribunal, sorry, but this is an urgent situation, if it is, and I tried and I couldn't. So please, tribunal, help me this. And I have the evidence, I have the pictures, and write everything. So everything, how this situation is. Don't make assumption that the tribunal are going to think for you. You write where you are living and how is this bad. So it's normal, obviously, if there are rats in your apartment, obviously, and you have children, there are a real it's obvious. It's obvious that have really impact in the health of the children and the security or the safety of the children. But don't assume that the tribunal is going to assume that. Write that down. Tell the tribunal how the situation is affecting you.
Thank you, Jael. There's a follow-up on that. If somebody has already emailed the landlord and is not hearing back and nothing is being done, if they want to contact the tribunal for further assistance, can they call you to get help to do that?
Yeah, of course. If they call me, I don't answer right away, so please leave a name and phone number and I call you back. Or you can write me also an email and telling me the history and even saying that you were at this webinar, and I can follow up as I can. Yeah.
We are at 2:50 right now, so I am just flagging the time. We're hoping to, I think, end in about a 50 to 60-minute webinar. There's no more questions in the queue at the moment. Just waiting for 10 more seconds. There's another question about whether the landlord, you've mentioned this before already, Jael, about retaliation, but the question is, can the landlord evict you for going to the tribunal?
No, it can't. As I said, you have to have evidence, but I think going to the tribunal to complain about safety of the premises and for example, the landlord not complying the obligations, and after having an eviction, as I said, it's important not to make assumptions that the tribunal will understand without you telling the tribunal. So tell the tribunal clearly, I truly believe that this eviction and this notice to vacate, it's as a result of my complaint. So it's important for you to be clear what is happening and not let to the tribunal to think for you, because they are not going to do that, unfortunately.
The question is, there's another question. What is the difference between the tribunal and the rentalsman office?
There is no difference. The rentalsman's office is just a change of name. The rentalsman's office doesn't exist anymore. They changed the name to the tribunal. It's that is the same office. And as I say, they changed the name of the tribunal, but they didn't change the structure. So now it's is an institution named tribunal, but not with a structure of a tribunal. They don't have right to appeal. If you don't agree with the decision of the tribunal, you have to go to court. So yeah.
Thank you, Jael. I'm not seeing any more questions at this time. I think we can there's one more question that's coming. We'll take that and we'll wrap up here. The question is, what if the landlord won't fix your apartment's issues and then says they will evict you if you go to the to the tribunal office?
Oh, record that. Send an email to the landlord saying that this day you told me this. And I think that is unfair. And after, with that evidence, you go to the tribunal.
And can the person call you or email you for help with that?
Do it. Yeah. Please, this person can call me or send me an email, and I will be happy to help. Yeah, it's that is clearly retaliation, and no, that is not gonna. It's important to keep it record and to make the complaint. Yeah.
Okay, with that, I think we can close up. And so, Jael, if you have any final things you want to tell people.
Yeah, because this webinar will be recorded and I share it, so I'm sending a message for the people who are seeing the webinar later. There is my contact information, my email, my phone number. So please feel free to call me and leave in your name and phone number, or send me an email, and I will be happy to follow up and to help you. Remember, I'm not part of the government. I'm not part of the state. This is a position for the Coalition for Tenant Rights, which is a collective activist. So, but I'm really happy to help and to help the tenants to navigate the system and to try to find solutions. Yeah.
Thank you, Jael. Thank you, everybody. We are going to stop the webinar now.